Okay, so today we're going to talk about Miranda. That is the Miranda v. Arizona case that we all now know through a million different police shows as your Miranda rights. And so we're going to do our coffee talk and discuss that here for the next 10-15 minutes. But there's all kinds of social media platforms, and a 15-minute conversation doesn't always play well with those. So here's the Twitter version of the video. Stay quiet, get your attorney. Hashtag lawyers. Hashtag Constitution. Here's the TikTok version. Remain silent. Get an attorney. And then now we'll get into the format that I like better, which is a more in-depth conversation of Miranda and your rights associated with the Miranda case. Hello everybody, welcome to another Coffee Talk. I'm Brett Knight, and as is usual, today we're going to dive into the law a little bit. We tend to focus on legal issues and how they're impacting you. And today we're going to talk about remaining silent. Specifically, we're going to talk about the decision in the court case of Miranda v. Arizona and what we have come to know in the American system as the Miranda rights. So we'll kind of dive into that. But before we go all the way back to 1966 and Miranda v. Arizona, it's probably worth mentioning, I don't know that there's a more confused and issue that I have to deal with on an almost daily basis than Miranda rights. It seems like almost every day that I'll have a potential client or a client come in and they'll talk with me. And inevitably, one of the most popular questions I get or statements I get made is, I wasn't read my Miranda rights. Does that mean my case is going to be dismissed? Okay, so we're going to get into that throughout this conversation, and we'll probably be here for about 10 minutes or so, maybe a little bit more. It's hard to talk about a topic in any kind of detail and not spend at least that much time on it. So we'll dedicate that time today to talk about Miranda and what it means for you. So we go back to the beginning in Miranda v. Arizona, and what it was a case where a man named Miranda, Mr. Miranda, he had been convicted of a violent crime. And his attorneys were attempting to overturn that conviction based upon the fact that his confession, his statements that incriminated him, was made without him knowing he had a right to remain silent. The court heard this, went all the way up to the Supreme Court, where the Supreme Court decided that in Mr. Miranda's particular case, that he was not informed of his rights sufficiently. And even though he had come in voluntarily to make a statement to participate in a lineup, that he made statements without fully understanding his rights. So in that court, they spelled out what we now refer to as Miranda rights. And anybody who's ever watched a cop show or a detective show, there's always a scene where officer maybe pulls out a card, or he says, you have the right to remain silent. Anything you say and do can be used against you in a court of law. You have the right to an attorney and have one present with you. And so we've heard those statements. And those came directly out of this Miranda case, where the court spelled out exactly what you have to do in order to fulfill or satisfy the requirements that a person not only has the right to remain silent and they have the right to an attorney, they have a right to be informed and make an intelligent and informed decision whether or not to give up that right to remain silent or give up that right to not have an attorney. That's what Miranda kind of boiled down to. It's not enough to have the right. You have to be informed, therefore you can make an intelligent and informed decision about waiving that right. It has implications of Fifth Amendment protections for making self-incriminating statements, Sixth Amendment right to counsel issues, 14th Amendment issues where it was applied to all the states. It began just federal and then was applied to all the states. So we've got several areas of the Constitution, the U.S. Constitution, that are impacted by the Miranda decision or that the Miranda decision draws from. But that's the root of it. That's the route that when you are in a police interrogation, we're going to break this down a little bit. When you are in a police interrogation and you are in custody, two very critical things that have to be in place, that you have to have full knowledge of your legal rights and understand before you can waive them. All right, so when does Miranda apply? Court ruled that interrogations are coercive in nature, and that as such, that's where these particular requirements of being informed and making informed decisions take place. So, for example, Miranda does not apply just anywhere and everywhere in your life. You don't have Miranda rights just walking down the streets. You have Miranda rights when you've been taken into custody and you're being interrogated about a particular crime by the police, by law enforcement. So that's probably one of the most confusing aspects of it. The decision, it consolidated several cases, California v. Stewart, Vignera v. New York, and Westover v. United States. Ended up being a 5-4 decision where Chief Justice Earl Warren in the Warren Court at the time said that, quote, "It's not admissible to do a great right by doing a little wrong." Further went on to say, "It is not sufficient to do justice by obtaining a proper result by irregular or improper means." So that's the court decision. There's a lot of information there, and since 1966, other courts have taken time to clarify and expand in some cases and detract from it in others. But what we're left with is this core belief and core set of rights that you have a right to remain silent, you have a right to have an attorney present with you, and if you can't afford an attorney, one will be provided for you. Those rights engage, as all rights do, at very specific times. You have a right to be told about these rights when you're in custody by the police and when they are asking you questions. So we talked a little bit about how Miranda only goes into effect and is required to be given those warnings at certain times, such as when you're in custody and when you're being questioned by the police. It also does not cover certain topics. For example, Miranda does not cover, you would not be required to be read your Miranda rights. You could not remain silent as to your identity. The courts have ruled that that's not in and of itself evidentiary. It's not something that would tend to prove guilt or innocence, and therefore is required. Miranda also engages a topic that the Warren Court, we talked about the Warren Court earlier, that the Warren Court had previously put into effect with Fourth Amendment violations, that is, violations of search and seizure, and it's something we call the exclusionary rule. And how that affects Miranda is, what's the impact if your Miranda rights are violated? And the answer is that the exclusionary rule would keep any evidence that was obtained illegally, that is, that was obtained through a violation of your rights by the police, would keep that evidence from being used against you at trial or at hearings. So that's the I guess the recourse given to you if your Miranda rights are violated, is that any statements you made and evidence obtained from that would be excluded from your trial. And that comes back, the exclusionary rule goes back to 1961, and again it was dealing with and applied to the Fourth Amendment originally, because if you think about it, in 1961 we didn't quite yet have Miranda, which would come 5 years later from the same Warren Court. And Matt v. Ohio, though, recognized the exclusionary rule as a tool to safeguard the Fourth Amendment and a way of making law enforcement follow the laws and rules in obtaining evidence. The idea being that law enforcement would be less likely to violate somebody's rights and obtain evidence illegally if they knew that that evidence could not be entered into court and could not be used against the defendant. There are exceptions to the exclusionary rule. The independent source doctrine says that if law enforcement through an independent source would have discovered this evidence or this information, then it can be used. It's closely related to inevitable discovery, which again says that if law enforcement would have obtained this evidence outside, through an independent investigation from this violation, then they get to use it. That sounds a little confusing. I'll give you the story that I always remember from case law where this was kind of established. There was a man who was accused of a very heinous crime of murder of a child, and on the drive to the police station, he was in the back seat of the police car, and the police officer in the front began having a conversation with the man, and it was kind of casual. It wasn't like a harsh course of it was more psychological, in that this officer was talking about how this child deserved a good Christian burial, and that this child's family, deserved to have closure, and that this, child needed a good Christian burial. It's a good Christian burial speech, as we referred to it in law school. And the defendant in the back seat finally gave him information that led to where the child was found at. And my memory serves correct, I believe the child had been hidden inside of a culvert where the body was later found. The court ruled that was in violation of the defendant's right to remain silent, because he wasn't read his Miranda rights, that he was in custody, and this was, definitely an interrogation. But the court then allowed the evidence to be put into trial, because it said there was a group of people who were searching that area, and they were going grid by grid searching. And they had not quite yet reached this culvert area, but they would have inevitably discovered the body if they had gotten into that area and found it. So even though they didn't find it, the court ruled, well, they would have found it, and because that would have been an independent investigative means of finding the evidence other than the statement, we're going to allow it in. So there are some exceptions, within the exclusionary rule, which is why when people ask about Miranda, and they'll ask whether or not my case is going to get thrown out because I wasn't read my Miranda rights, the answer is no. And the answer is not necessarily, because the remedy for violating your Miranda rights is not throwing the case out. The remedy is not allowing the evidence, your statements, to be brought in. But there are exceptions to that. There are other ways in which information can come in. Those things have to be argued by your attorney in court in front of a judge, and the judge has to determine whether or not the evidence gets excluded. And even then, the case doesn't get dismissed. Even if you were to prevail at those hearings, the case doesn't get dismissed. The evidence is just not allowed in. And the state may very well proceed without that evidence. They may very well want to proceed without your statement and go forward anyway. So it does not mean an automatic dismissal. It just simply means that that evidence isn't going to be used, and it may impact the case. Now, your attorney might be able to argue that, hey, without that statement, that confession that was obtained against, my client's constitutional rights, you don't have a case to go forward. The state may even agree, but most of the time that would not necessarily be the case. All right, so let's kind of recap here, and then I'm going to answer some questions that I've gotten in emails and messages and try to make sure I've clarified everything. Miranda was a case back in 1966 that established that a person has a right to be informed of their constitutional rights through the Constitution of the United States, to be told that, one, they have a right to not incriminate themselves, and two, they have a right to have an attorney and have that attorney present. So Miranda was a case that said, recognized the rights and said that law enforcement has a duty to make sure that a defendant understands those rights so that they can knowingly and voluntarily waive those rights if they choose to, or not, to assert those rights and remain silent if they wanted to. But it has to be knowingly, and informed decision that was made. So that's Miranda in a nutshell. What Miranda does is it applies the exclusionary rule if the law enforcement has violated your Miranda rights, and the exclusionary rule is applied, and it's possible to make an argument at a hearing to have that statement that was made excluded from trials or hearings if the judge were to determine that in fact your rights were violated and it does not fall within any of the exceptions to the exclusionary rule. So that's what happens with Miranda. It's a lot more complicated than I wasn't read my Miranda rights, therefore the state should not be able to go forward against me. It's a lot more complicated than that. So let me answer some of these questions that I've received, and maybe it'll help others who might have the same questions who maybe just haven't asked them yet. Whew, I know that's a lot, right? It's a lot of information for early in the morning, but let's kind of recap in questions. I've received questions that I've kind of kept, knowing one day I'd have an opportunity to sit down and do this video. And they're questions that other people have asked me that might help you. Maybe you have the same question and you just haven't had the opportunity to ask. First question I have here is, I was asked, do the police have to read me my Miranda rights during a traffic stop? Good question. The answer is no, they don't. Courts have ruled that a traffic stop, even though you're detained from being free to go, has not risen to the level of custody where Miranda warnings are required for the conversation. So, for example, when a police officer approaches your window and begins asking you questions, he or she does not have to read you your Miranda rights prior to that, and any statement you make can and will be used against you in a court of law. So the answer to that is, no, it does. Miranda rights do not apply, and yes, your statements at a traffic stop can be used against you. Now, if your traffic stop advances to a level of a heightened stop, as I referred in previous videos where I've talked about police encounters and in a motor vehicle, and by the way, you see the link here on the top of the screen. You can click and go to that if you're interested in a much more in-depth conversation about a traffic stop and remaining silent. Next question I have is, if I'm not read my Miranda rights, will my case be automatically dismissed? I've kind of answered that previous up to now, but let me just go ahead and put it into a nutshell. No, not necessarily. First, does the issue be raised properly by your attorney before a judge, and the judge would have to make a determination. And even if the judge made a determination, the result would not be your case being dismissed automatically. It would be that the evidence would not be used against you, and that is your statement not being used against you, which is oftentimes how this is presented to me. I'll have a client who will say, I was pulled over and I was charged with whatever, DUI. And they never read me my Miranda rights. Well, first, as the first question we just went through, they probably didn't have to in the beginning of it. They were just, encountering you as a police stop, and that doesn't rise to the level requiring Miranda. And probably once you were put into custody, they probably quit asking you questions at that point now, and you probably quit making statements. So a lot of times that's the next question I'll ask. When somebody says to me, I was not read my Miranda rights, will my case be thrown out? And my next question to them is, well, did you make any statements? And if the answer is, well, no, I didn't make any statements, well, okay, we don't have a Miranda issue then, because you weren't in custody and being interrogated or questioned by the police. So you don't meet those two requirements that are there. So if you're not being asked questions, obviously Miranda doesn't apply because there's nothing to exclude. All right, next question. Can my remaining silent be used against me? That's a little bit more complicated than you might think. You might expect an answer of no, your remaining silent can't be used against you. It cannot be used against you to prove guilt. However, remaining silent can be brought up. The fact that you remain silent can be brought up. There just cannot be a connection between your remaining silent and guilt. Also, remaining silent prior to your Miranda warnings or prior to Miranda engaging, the rights in Miranda engaging, your silence could be used. So, for example, if I remain silent, before I'm in that, situation where I'm being questioned by police and I'm in custody, where Miranda would kick in, if I'm remaining silent prior to that, the state could use that against me, or at least attempt to use that against me, that, I remain silent where a normal person maybe wouldn't have. It gets complicated, and that's why you have to have an attorney kind of parse the fine detail and split those hairs. But the courts have, laid out a foundation and a groundwork for us to kind of understand, based on your particular circumstances, what would apply. Let's see, next question. Do the police have to stop asking me questions if I request an attorney? Yes. If you've made it clear that you want an attorney present for your questioning has to stop at that point until you have an attorney present. And then you have a right to meet with your attorney outside the presence of law enforcement without them recording it or listening in prior to going in and deciding if you want to answer any more questions or not. Kind of follow-up to that, a related question, another question I had was from a different person. Do I have to say I want an attorney out loud, or is it assumed if I remain silent? Okay, some people can maybe overthink this, and they think, well, I've got to remain silent, therefore when they ask me if I want a lawyer, I'm just going to remain silent. And the courts have ruled, and it might be surprising, the courts have ruled your silence is not an assertion of your rights. So the police could continue asking questions. They could continue, monitoring your body language, and they could, use that against you. So there was a case where a man was being interrogated for hours, and they would ask if you want an attorney, he just wouldn't answer. And then eventually he made a statement, and then the courts allowed it in by saying his silence was not an assertion of his rights. It's not the time to be wishy-washy, okay? I guess I just say this as plain as I can, because I think this is important for people to hear. And if I could insert one set of knowledge for people just to understand, as a criminal defense attorney, a former prosecutor, a criminal defense attorney now, I've been on both sides of these issues. The one piece of information I want people to understand is remain silent and ask for your attorney. So I'm just going to be, talk plain here and say it. You cannot be wishy-washy. This is not the time to be weak, and this is not the time to be wishy-washy. You have to say with no uncertainty whatsoever, I want an attorney. I will not answer any more questions until I have an attorney present. I am going to remain silent and not answer any questions, and then be done. But you can't, if you state it in the form of a question or of uncertainty, it's not an assertion of your rights. The courts have ruled that. So if law enforcement says, well, do you want an attorney before we talk? Or is it okay if we talk to you without an attorney? They'll put it in a very positive spin because, well, they've been trained very well on how to do that. And your answer is, well, I guess maybe I should have an attorney. That's not enough. That's not enough. You have to say, I want an attorney. I need my attorney present in all questioning. You have to say it very specifically, without question, without any kind of ambiguity. You have to say, I want an attorney. I do not want to answer any questions until my attorney is present. I am going to remain silent. Remaining silent is not enough. You have to state, I am going to remain silent. That's what you have to do to get your rights in there. So again, hey, at this point you're getting arrested, you're in custody. It's time to put on our, big boy pants or big girl pants and assert your rights and say, I want an attorney. I'm not going to answer any questions, and I'm going to remain silent. And that will end the conversations until you have an attorney and you're able to understand the situation, understand what you're being accused of. Again, as we've talked about in previous videos on here, the police have no legal responsibility to or obligation to, no policy or sense of duty that they have to be honest with you or tell you the whole story. They can present you verbally with information that is not correct in an attempt to get you to admit to something. So trying to talk your way out of it without looking at the proof is a way that you get yourself in trouble. That's why I said earlier, if I could just get one piece of information out to the whole country, it would be assert your rights. These rights are given to you for very good reasons. We've seen what happens when people don't assert these rights or these rights are not given to them. You've got these rights, use them. All right, I'll get off my soapbox, I promise. Last question I got here is, once I remain silent, does that cover me for all questions going forward? No. There is actually a period of time in which law enforcement can come back. So, for example, if I'm in a jail cell and the police come and the detective comes and says, Mr. Knight, I want to ask you a few questions. Are you okay with that? You have a right to remain silent. You don't have to talk with me, and you can have an attorney if you want one. They've kind of gone through my Miranda rights, right? Because there's no specific of exact words you have to use. He's kind of going through with me my Miranda rights. And if I say, no, detective, respectfully, I'm not going to answer any questions. I'm going to assert my right to remain silent. And he says, okay. And then he leaves. And then, 2 days later, 3 days later, comes back and says, hey, Mr. Knight, just thinking about you and your case, I really would like to talk to you. I think it could help you if you talk to me. He's okay. It's okay to do that because now I need to reassert my rights. They're not ongoing forever. So there is a reasonable period of time in which law enforcement can come back and ask you. All right, so I'll be glad to answer other questions. Email me, message me on Facebook, or leave the comments here on YouTube. Whatever works for you. I'll be glad to answer questions about Miranda. Again, it's a lot more complicated than what some people think it is. It's not as simple as I always have to be read my rights, and if my rights aren't read to me, my case is being dismissed. And that's not true. One, your Miranda rights don't kick in unless you are in custody and you're being interrogated by the police. And the remedy for your Miranda rights being violated is not your case being dismissed. It's the information that you stated cannot be used against you at trial if it's shown that they violated your rights and that it doesn't fall under one of these exclusionary rule exceptions that are there. So that's why you have attorneys. That's why you remain silent. That's why you have attorneys on these kind of cases to dig into these details. Just like our conversation here is not legal advice because I can't answer your specific questions about your case. That's why you need to talk with an attorney if you're in this situation, so that they can hear your specific information and then give you legal advice. This is, casual conversation we have over coffee where we talk about the law and how it impacts you, and I'm glad to do that. A lot of people feel like, well, it doesn't seem fair that people are accused or, the evidence, maybe they make a confession and then it's not used because the police didn't, read the Miranda rights properly. And but that's our Constitution, and that's how in our justice system, that's why, to me, it is the best justice system in the world. And it's a system that I don't think always gets it right, and it's not perfect, but I'm very proud. I think it's the best example that we have, and we continue to try to make it better. But that's how we feel in this country, is that we do not want law enforcement obtaining evidence illegally. And if they do obtain it illegally, then the punishment is not that the officer goes to jail, not that the officer gets fined or that the officer can be sued, because they have actual immunity to a lot of that, but that evidence will not be used against them, and that can be a punitive thing to keep law enforcement from doing that again in the future, and therefore protecting other people's rights. Some people might ask, well, why doesn't law enforcement just read Miranda rights every single time? I'll tell you, when I was a prosecutor, I advised law enforcement, and every time I was involved in an interrogation or I knew one was going on, I always told them, read them their Miranda rights and have them sign on the waiver stating that they understand them and that they're waiving them prior to talking with them. To me, it just wasn't worth the risk, and I didn't want to ever trample on somebody's rights, and it wasn't worth the risk of having that evidence thrown out later on in court. But some law enforcement officers, prosecutors would disagree. They'd say, well, it's worth the risk. We'd rather kind of play closer to the flame, because we feel that if we read them their Miranda rights, it would have a chilling effect on them having a conversation with me. Yeah, I guess constitutional rights tend to do that at times. But so I tend to fall on the other side of that and disagree with that statement. Again, I've had conversations both as a prosecutor and as a defense attorney when, sometimes evidence will be thrown out through the exclusionary rule, and the officer will get upset. They'll say, well, I can't believe you got that evidence thrown out through a loophole, or I can't believe that attorney got the evidence thrown out through a loophole. And I was always quick to say, as a prosecutor and as a defense attorney, to say respectfully to the officer, well, actually, they didn't get it thrown out, or I didn't get that evidence thrown out. You got it thrown out. You're the one that didn't follow the rules properly and advise the defendant of their rights, and you knew you should have, but you chose not to because you didn't want to have that chilling effect on the conversation, and you took that risk, and it just didn't pay off for you this time. So that's how I kind of look at it, kind of as a odd twist of events. I always found this kind of interesting, so I'll share it as my closing part of this video. In case you were wondering about Mr. Miranda, Ernesto Miranda, the original case back in 1966, where the court ruled that he was not read his rights properly, and he was accused of very serious violent crime. And so they went back to trial, and they said, okay, well, you can't use his statement, you can't use his confession. And they went back, and the state, in Arizona, retried him without his statement, and he was convicted. So he ended up going to jail until 1972 off of that. So he did, in the end, the court ruled that you can't use that illegally obtained evidence. The state went forward without the illegally obtained evidence and was still able to get a conviction. So they didn't need to have done that in the beginning. And they convicted him. He ended up being in jail several more times until 1976. And a very odd turn of fate, karma, or whatever you might call it, he got into a bar fight and was stabbed to death. And I don't mean to laugh because it's not funny, but the twist of fate is kind of quirky. So he was stabbed to death in a bar. The assailant who stabbed him was read his Miranda rights and chose to remain silent, and was never convicted of the crime. So in the end, Ernesto Miranda's own homicide case ended up being a case that revolved around a Miranda warning. So just an odd closing there of Miranda. Thank you again for joining in with me. Again, my name is Brett Knight. I'm an attorney with here in Tennessee with the law office of Fry, Knight, and Looper. And we appreciate you watching these videos. As always, we would encourage you to subscribe to our page here on Facebook. We put a lot of videos up here. We have a series that we've just started called Police Encounters, where we kind of dive a lot more in depth into specific police encounters and your rights that you have and the laws that impact that. And then, of course, we have always got more of these coffee talk conversations. And if you subscribe to our page and to these playlists, then you'll get alerts when we add new videos. And by all means, leave us a comment. Let us know what you think. Have a great day.